Hi, and welcome to another edition of the Trustcast Show. And we're really happy to have with us John McKenna and Lou Mincarelli from
Hello,
MacElree Harvey. Did I do that right that time?
MacElree Harvey.
McElree.
Yes, close.
MacElree Harvey. Hey, welcome, guys.
Thank you for having us.
So today's guests are colleagues at one of the oldest law firms in Pennsylvania. They got there from completely opposite directions. John McKenna spent 12 years as a psychiatric social worker before going to law school and has now spent nearly 4 decades untangling some of the most emotionally explosive disputes a family can face: wills, will contests, guardianships, and trust fights. Lou Mincarelli went the other direction. He started by sitting with crime victims in the Philadelphia DA's office, worked his way up to the major trials unit, then took 60 jury trials to verdict, then became a judge twice, nominated to Chester County bench by 2 separate governors, and is now back at
MacElree Harvey.
MacElree Harvey. I don't know why I have a brain fart there. Doing what he loves. John, Lou, before we get into all of it, you two work together every day. What did you each think of each other on the first day you met?
Well, I was pretty impressed by the judge. I call him Lou, but a lot of people call him Judge. He's still thought of as a judge in this county, but he has honed his skills in the courtroom, both as a litigator in front of a judge and then being the judge himself as an actual Court of Common Pleas judge in Pennsylvania. That's what we call our state court. It's the Court of Common Pleas. And so I was very impressed by him immediately. Really warm, open, well liked by his colleague judges and also his colleague attorneys. So that was my impression as well.
I was very impressed with John. He's been, despite my experience, he's been a mentor to me in this process of going from the bench to the bar, and then back to the bench, and then back to the bar here. And he's been helping me make a really smooth transition. I'm excited to be able to work next to him every day. He's, like I said, a mentor and a good friend and a colleague. So I'm excited to be able to try to build this practice that we're putting together. He has a ton of experience, and he's been a great source of knowledge for me to be able to help our practice group really hopefully pick up and explode. He's got an excellent reputation among my former colleagues on the bench. So when I was choosing where I wanted to go after I got off the bench the first time, this was the clear choice for me because of the reputation of the firm being one of the oldest in the state. I think the oldest in Chester County. But not just that, but the quality and caliber of the attorneys that we have here. We have about 40 or 50 attorneys in 4 different offices, and we have a wide range of practice areas. And John's just been a great resource to me.
So tell me about your practice areas. I'll just start with you, Lou. What is the breadth of what you practice there at
Sure, I do a
MacElree
lot of
Harvey?
litigation. Sure, I do a lot of litigation, as you stated in the intro. I started my legal career as an assistant district attorney in the Philadelphia District Attorney's Office. I had to be a crime victim advocate there, and I worked my way up through the office. Got a lot of trial experience in Philadelphia. Went into practice for myself with a couple of partners in a firm that's no longer in existence, and did a lot of criminal work, did some civil, a little bit of civil litigation, a little bit of family law. And then when I got appointed back in 2022 by then Governor Tom Wolf, I sat in family court division and the criminal division. And I also presided over juvenile delinquency matters. And when I got appointed again last year by Governor Shapiro, I sat in the civil division. So I've sat in every division in and as John had said, the Court of Common Pleas is our trial level court here. There's different names for different states have different names for it, but this is our
Mhm.
trial court. And so I've sat in every division except for Orphan's Court, which is one of John's actually expertises. He has a lot of experience litigating in the Orphan's Court. He sits um, um, as a mediator in the orphans court, and that's by the judge's design. They choose him because of his experience and the amount of time that he spent. So I think combined, we were able to sort of give a 1-2 punch as far as being able to cover pretty much every aspect of the law with our combined experiences.
So when I hear orphans court, that piques my my curiosity. John, can you talk a little bit about that?
Certainly can. It's a kind of unique to Pennsylvania. Other states call it probate court, decedents, estates, that kind of thing. But basically, orphans court involves wills, trusts, adoptions, also guardianships of people who are incapacitated or children who sometimes they don't have a parent or their parents are passed and they need somebody to take over the guardianship. So what I do is the courts appoint me to resolve a litigation piece, and usually it's a fight over who gets mom's money, who gets to have possession of the child, who has the custody of the child. But it's more of a one. It's different than a divorce case where you have two people are fighting over a child. This one is that there is nobody fighting over a child, and usually what I do is resolve that issue. And also, there's a lot of problems with the people who are approaching senility, and they need a guardian to watch over their assets, to take care of them, to make sure that they're getting their proper care.
So if my parent just died and the will's completely different from what we were always told, and you're representing the person who is in that situation, what's the first move?
Person who thinks that they've been cheated, basically?
Yeah. Person
Okay.
who thinks it.
Well, that you would file a petition in orphans court challenging the will, saying that it was a product of undue influence. There was fraud involved in the writing of it. The person, when they wrote it, was drunk, on drugs, and the person who got them drunk or got them high was a bad person, the evildoer, and we sort that out. But that's where the mediation comes in, because litigation can be a very expensive process. Mediation is a much less expensive process. Hopefully, most of the time, it's a one-shot deal. You resolve the case the same day you start it. So when they come in, your job, my job, is to facilitate a resolution, to make sure that both sides understand what their strengths and their weaknesses are. I've been in trial so many times that the lawyers who bring their clients to me know that I've been there and I know what's going on in their cases, because they also write like a real short synopsis of their cases so that I can review it and say, okay, so this is the so-called undue influencer. This is the person who was the child and thought that he or she was getting everything under the sun, under mom or dad's will. So
What
And that's the
is
benefit of
undue? Go ahead. Sorry.
no, that's the benefit of mediation or arbitration in any practice group, really, whether it's civil or orphans or family court, because as John alluded to, there's a lot of uncertainty, a lot of cost, a lot of time that has to go into waiting for those cases to go to trial. I've litigated a lot of cases. John's litigated a lot of cases. I'm sure he'll tell you that he's won cases he probably should have lost, and he's lost cases he should have won. Same thing with me. I've won cases I probably should have lost, and I've lost cases that I was confident I was going to win. And those are things that you need to have conversations with your clients before proceeding, or whether you want to explore the option of doing some sort of alternative dispute resolution. And that's where we come in, because we're not just trying to pitch a product, so to speak. We're talking from a position of having been there and done that ourselves, having to deal with clients, and any client, whether it's an orphans court matter, civil court, family court, whatever it happens to be, there's an amount of emotion that takes part. They're aggrieved in some way, or they feel an emotional attachment to certain facts or certain aspects of the case. As the advocate, as the attorney, we have to be the dispassionate advocate for them, and try to explore all options. That's what we try to explain to attorneys on both sides of the courtroom, that we're an option for them to try to get this to resolution a lot sooner, um, with a little bit more control, and empowers in the mediation aspect, and empowers the both sides, because there's no one's forcing them to settle the case. It gives them an option to settle it. The mediator, I have a mediation I'm going to be doing tomorrow. My role is going to be to try to facilitate an amicable resolution, but it really, the parties are the ones who are empowered to come up with that resolution.
So when I do a mediation, so I mean, logically, if you, do you sometimes have to separate people into separate rooms in order to keep
good.
the temperature down in that kind of scenario?
Sure.
Yeah, I think that we call it caucusing. So we take one party out of a room and put it in another. Usually have at least two rooms. Sometimes I like to have three rooms because I can take the lawyers, let the clients sit in their own separate rooms, and take the lawyers into a third room and say, look, guys, this is what I think, and this is where I think this is. You got to tell your client that if they keep this particular line of attack going on, they're going to fail miserably in a courtroom. And just about 100% of the time, they know I know, and I tell them so. And I think honesty is really, you got to let the lawyer know and the clients know that their case is strong or their case is weak, number one. And number two, to find a way they can live with a solution that would solve the immediacy of the problem.
Yeah, I was involved in a litigation some number of years ago, and I thought the opposing counsel was so exceptional that I had something else come up a couple of years later. I called him back, and he remembered the litigation, and I said I thought he was great, and he says that's really funny because the client that I had thought I was horrible, and he says that must be we came to a good resolution because when nobody is really completely happy, that's probably about right.
Right.
I
Yes,
don't know
that's
if
correct.
that's so. What's the difference between arbitration and mediation?
So in the mediation, what happens is, again, that's more empowering the parties. The role of the mediator, whether it's John or myself or whoever, our goal is to try to bring the parties together. What I do, it's just like it's synonymous with when I was a judge. I sat in civil court last year. I did about 50 or 60 settlement conferences with, as a judge. It's the same thing, except as opposed to being the judge, I'm someone that's contracted by both sides to try to bring them together. The way it works is I'll get confidential memorandums from each side prior to the mediation, which will sort of outline their view of the case. I'll try to get what's the latest offer, what's the latest demand. There may be information that they don't want me to share with the other party, that this is their limit, this is where they're willing to go to, this is where they're not willing to go to. Um, and then it's just a conversation, like John said. We sit them down the way I did it, whether it's a settlement conference as a judge or whether it's a mediation as a private attorney. I get everybody in a room together in the beginning. I introduce myself. I'd explain sort of the ground rules that I'm not there to take a side. I'm there to help facilitate. And it's really them empowering themselves to try to come up with an amicable resolution because they're saving the time, money, and uncertainty of litigating it. And then I take them, I caucus with them, and that's when I call it arm twisting starts happening, and try to get them closer together. A lot of times it works, sometimes it doesn't, but a lot of times it does work. And you have to just have reasonable expectations and client control. I think if you're an advocate, you have to have your client prepared to understand that it's not going to be a home run. It's about trying to come up with some sort of an acceptable resolution. An arbitration is different because it's myself. I could be either a neutral in a 3-panel arbitration where there's someone from the defense side, somebody from the plaintiff side, and then I'd be the neutral, or just a one-person arbitration where I'm the person that's deciding. It's sort of a mini trial, but it's a little bit more streamlined. It's a little bit more cost effective because there's a lot of things that you wouldn't need to do if you were going to do, for say, example, for a jury trial. It could take a day, half a day, maybe 2 days, depending upon the complexity of the case. but it's really cutting down the amount of time that people are spending litigating, because some of these trials could last 2, 3, 4 more weeks, depending upon how complex it is. And then John has an area called collaborative arbitration, which I'll let him explain what that is.
Well, I'd be glad to. Collaborative arbitration is kind of another way of saying binding mediation, and here's the difference. In arbitration, the clients, the people sitting in this, they're swearing in and they're tell the truth, the whole truth. At the end of the day, at the end of the arbitration, the arbitrator will grant an award to one or the other. And there's, there's very few grounds that they can appeal on, but most of the times that's it. Case is over. Some people don't like to do that because they don't have a say necessarily, other than they can testify.
Right.
Collaborative arbitration or binding mediation is a situation where the parties have a say. It's called putting people back in the process. They actually get to be able to participate, tell the mediator / arbitrator where things are. However, the difference is, unlike a mediation where everybody voluntarily enters into an agreement, at the end of the day, if I can't get them to agree, then I actually make the decision. The way it's worked out, though, has been very interesting and has worked out well. And that is, they know that I can make that final decision, so that I can steer them and say, I'm kind of thinking XYZ. You're thinking ABC. I'm thinking XYZ, and here's why. And then, I don't think your case is worth $1 million. It might be worth $100,000, depending what it is. So it's putting people back in the process. They're getting to know the reasoning and how they're perceived by the arbitrator, as opposed to an arbitration where you don't know what the arbitrator's thinking. They just make a decision, and that's the end of the case. So at least we give people a chance to explain, and also maybe more of a insight into what the actual outcome would be and should be. And that's where we go. That's what we go for.
Is that something unique to Pennsylvania?
It's not unique in the United States. Let's say I've seen other people talk about collaborative arbitration and binding mediation. I don't know anybody else who does it other than myself right now. But that's only because I'm in Delaware Valley. The Philadelphia area is a fairly densely populated area, and there's 5 counties that we deal with. Plus there's Delaware and New Jersey, which are all kind of mixed in what they call the Delaware Valley. And I don't know of any, but I think that it's also a new technique that I'm kind of ushering out to the audience and to the world, and see what people. I think it's going to catch on too, because I think sometimes people want to have that interaction.
So, what's the advantage of doing it that way? Now I want to dig in a little bit more about collaborative arbitration. So, when you're in regular arbitration, then you have this back and forth. You may have between the attorneys and the parties, and then you're trying to come up with an agreeable, compromise of some sort. When you have collaborative arbitration, it's similar, but you have one person who ultimately can make the decision, but doesn't necessarily. Is it?
Well, let me just point out one thing, that in arbitration, it's like a trial. You're actually in front of a judge, but that's called an arbitrator. The arbitrator.
You said collaborative.
Right. Collaborative arbitration is the same as binding mediation. The terms are used interchangeably,
Okay.
but mediation and arbitration are distinct, different things.
Right. Okay, I got it. I was mixing up the two.
That's right. No problem at all.
Two categories.
Yeah, the arbitrator acts. They're sort of, I hate to use the term, but they're sort of a hired judge almost. They're contracted by the parties to sit as a judge over this, and it's binding. It's legal. It's final in most cases. And as opposed to preparing to go into a courthouse in front of a judge or in front of a jury, and all the formalities and time that takes, um, I would, or John would, or whoever would be the arbitrator would sit in lieu of that judge and hear the evidence, watch the witnesses be questioned, cross-examined, and then at the end make a decision and a reason for
So
that
the
decision.
so the collaborative arbitration is kind of taking the best of mediation and then putting it into arbitration so that you
You got it.
know that you'll distinctly get a decision at the end, but you have a chance to discuss things over more comprehensively. Am I understanding that?
You are getting that very well. And also, what's really important is that um, many times, because they know that I can make a decision by me reflecting to them what the outcome could be or the way I'm leaning in this direction from what I'm hearing so far, the parties can then say, because they're going to give me all the evidence, they're going to give me the pleadings, they're going to give me the exhibits so that I can review it. It's just, but it's putting, like I said, it's putting people back in the process. There's also a stage in both arbitration and, excuse me, mediation and binding mediation. And that is, there's going to be a point sometimes when people are going to need patience the most and they'll have it the least because it's been going a lot of times it's been going all day long. And they've reached a point where they just can't take anymore. And I always remind them that's the time when you're going to need patience the most because now you're getting close to the end game, which is resolution. And that's what you want. You want resolution. And also one other thing that the judge brought out in arbitration, it's a lot less expensive. And that's another consideration. A jury trial with evidence and witnesses and discovery and deadlines and pretrial motions and all these other tools that lawyers use uh, is sometimes 4 and 5 times more expensive than an arbitration would be
Mm-hmm. So,
because it's
Lou, I'm
just
going to
one
shift
guy.
gears a little. Go ahead. So I don't want to
No, that's
interrupt
it.
it.
That was it.
I was
That's
going
it.
to shift
Thank you.
gears here. So, Lou, I just got arrested. What are the first 2 things I should do before I say a single word to anyone?
Make sure A, you don't say anything, and B, contact an attorney. So, uh, anybody who's ever going to be questioned by whether you're guilty or innocent, you should never really speak to the authorities without having an attorney present because the police are there to try to get to the heart of the matter, of course, uh, but they're not there to represent you. They're there to find out what's going on, and they're able to use a lot of different means. They're allowed to be deceptive. If, for example, John and I were suspected of stealing Zane Myers jacket, and they put us in separate rooms, they could say, Lou, why don't you tell us what's going on? John already told us what's going on. He's making it better for himself. Why don't you make it better for yourself? They're allowed to do that. They can't hook you up to paracables and torture you to give a statement, but they're allowed to be misleading, and they don't have to tell you the truth. So you have Fifth and Sixth Amendment rights, and I always urge everybody to utilize them. I mean, they're there for a purpose, and once they consult with an attorney, whether myself or someone else, we decide if we want to make a statement. We decide collectively, and I would advise them as to whether it's in their best interest um, to speak or not. A lot of times I have clients that contact me because they get contacted by the federal authorities. They get subpoenaed by a grand jury. Sometimes they're targets of those grand juries. Sometimes they're just people of interest, and it's hard for them to know what is what. So it's always best to sort of take a time out. I always sit down with them, and I always say to them, if you are going to speak, you can't lie. You have to tell the truth, because lying is a crime in and of itself. So you need to sit down. We need to go through everything. If you say this, you're going to be incriminating yourself. So it's best not to say anything at all, or you have nothing to hide. Let's go down there. I'll make sure that it's a fair process. I'll make sure that your interests are being represented. I'll make sure that someone's there to look out for you. But you have to make sure that if it's X, Y, and Z that they're interested in hearing about, that you tell them about X, Y, and Z. And if they're asking you a direct question, give them a direct answer, but it's got to be truthful and honest.
So a lot of people are surprised, and that police can just outright tell you a bold-faced lie, and they're fine. There's nothing illegal about that. They can say whatever they want to say, in order to get at you to give some sort of evidence. Are most people, I think, are unaware of that. Can you talk a little bit about that?
Well, again, they can't force you, right? But
Right.
when you're you're giving your Miranda. One of the misconceptions is that people think, well, I was arrested, but I was never read your rights. Well, Miranda only kicks in when you're being interrogated, when you're being questioned. So usually, especially in Pennsylvania, different states may differ. But when you're being arrested by uniformed police officers here in Pennsylvania, typically you're not going to get read your rights because they're not typically questioning you. It's only when there's a custodial interrogation or an interview, they don't call it an interrogation, they'll call it an interview, that they'll read you your rights, and they're outlining what the rights are. You have a right to remain silent. You have a right to an attorney. Those are the two main things, your Fifth and Sixth Amendment rights, which I would urge people to exercise, because anything that they say probably will be used against them. And the problem is that it's not going to be all the good things that you say about yourself that they're going to use. If they think that you've committed a crime, they're going to use the bad things that you say. So it's important to not speak. As much as you may think you're going to talk yourself out of a situation, you're not going to usually, if they think that you committed a crime. So it's, when you get your phone call, I would contact a family member and arrange to speak to somebody, and um, make sure that you revise your rights, and exercise them.
So if
But
you
yes,
haven't ever been,
they can mislead, and that's um, just the fact. I mean, it's an investigative tactic, or technique that they'll use. They'll separate parties. That's why when they interview multiple suspects, they'll keep them separate, because you don't know what's going on in the room next to you. And they're not doing this because of any nefarious reasons.
Mhm.
They're looking to get to the heart of the matter. It's a technique that they'll use to try to um, get people to come forward and tell what they know. Um, because remember, their responsibility is not to for that person that they're interviewing. Their responsibility is to investigate crimes. So they're going to use the tools that are at their disposal to do that.
So Lou, you took 60 juries to verdict. What's the biggest thing juries consistently get wrong about how they're supposed to decide a case? I mean, you saw that from the judge and on the other side too.
So I've spoken to a lot of juries after the fact, both as a prosecutor, as a defense attorney, and as a judge. And there's a lot of intelligent people on these juries, but a lot of times they're all over the place, and you just don't know what's going to resonate with them. I guess what I would say to young trial attorneys is you just can't take any particular set of facts for granted. It's the job of the litigant to, whether you're representing a claimant in a civil case, or whether you're representing a defendant in a civil case, whether you're representing a defendant in a criminal matter, or you're prosecuting on behalf of the people of a particular jurisdiction. It's your job to sort of spell out the case. The judge is the one who reads them the law, but in Pennsylvania, we have model jury instructions that most judges will read. It's almost a script. And that's usually the most. When I was a judge, I used to feel bad because it was probably the most boring part of the trial for the jury, when they sat there and just listened to me read for a couple of hours. Um, but I think juries try to get it right. Do they always get it right? If they come up with a reasoned verdict, that's justice. That's what we tell them. We may not always agree with the verdicts, um, but I think that they're pretty responsive, pretty receptive, and pretty smart by and large. I think that they get a lot of things. So I don't know if they necessarily miss anything, but it's the job of the attorney on each side. If there's a particular aspect of the law that your case is going to hinge on, you got to hammer it home. You can't assume that 12 law trained people who are not trained in the law are going to necessarily get it, even after the judge reads them the law. You want to hammer it home, put it in their own words, and put it into bite-sized pieces for them so that they can digest it and hone in on it.
Can a judge overrule a jury from the bench? And under what, if that's the case, how would that happen?
Sometimes they can, in a criminal matter, they can, before the jury gets the case, the judge could grant a motion to set aside a verdict. In a civil matter, they could do that too. I think that's very rare for that to
Right.
happen. I, as a judge, I would very, very rarely even entertain that. There were some, maybe in some criminal cases, I've argued as a prosecutor against an attorney, and for certain aspects. As a defense attorney, you always make the argument that the Commonwealth didn't meet their burden on certain elements of certain crimes. That's just sort of the way it works.
Mm-hmm.
It doesn't often happen. Sometimes it will happen, but it's not a common thing. I think that when I was a judge, it would be very, very a very strange circumstance for me to do that, because I would want to obviously put the faith of it into the jury, and respect the decision of the jury. Unless it was something really out of bounds, something that was very egregious, I wouldn't step in.
Like misconduct or something like that from an attorney, and I guess it would. That was just my own curiosity. It wasn't here on my list of questions. I was just kind of
sure if it was something that happened during a trial, for example, if there was in a criminal matter, for example, if something came out that wasn't supposed to come out, that was going to unduly prejudice the defendant, I wouldn't sua sponte do it. But if a defense attorney would make a motion for a mistrial, we would explore that opportunity, that option, and see if it was appropriate to do that. I've made motions for a mistrial based on different things, because a lot of stuff is done outside the jury's presence, and that was one of the things I've noticed being a litigator as a judge. And I would warn jurors that they shouldn't read anything into it, but they get started late. They think that we're sitting around drinking coffee in the morning. We're not. There's a lot of things that we litigate outside their presence, and there's a reason for that, because there's certain things that they shouldn't know or shouldn't hear. And if certain things are precluded from coming in, and it somehow slips in, whether through some accident or maybe not an accident, then it's up to the judge to make the determination whether this is something that we can fix here in this trial, or whether we have to start all over again.
So, okay, I got just a couple rapid fire things. I like to break things up in the middle. So, John, rapid fire. You've been president of the Chester County Bar Association, the Bar Foundation, Legal Aid, and the Art Association. What are you actually like on a Sunday morning?
Sleep. Probably sleep more than anything else. No, I'm an avid hiker, and we travel a lot. But on Sundays, especially, sleep is a good thing.
Okay, Lou. So, prosecution or defense, if you could only do one for the rest of your career, which would you pick?
Oh, that's a tough question. I enjoy doing both, to be honest with you. That would be a tough decision on the criminal side. I think if I had to do anything for the rest of my life, it would be serving as a mediator and arbitrator. This way I can try to get both sides to in their civil cases, to try to get their cases resolved without having to go to trial.
There's a couple more. So, John, you wrote an article where you basically argued that most estate disasters come down to one word: communicate. What's the one conversation families refuse to have that costs them the most?
Usually it's why they did what they did. So, for example, you're cutting out your son because he hasn't talked to you in 20 years. That son, believe it or not, when the person dies, the son will say, I didn't know that. I didn't know I'm busy. I live on the other side of the country, or blah, 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 blah. There's different reasons for it. So I believe, and I know I'm somewhat of a minority in this, because I think people want to avoid difficult conversations, but I think it's important to let people know why you're doing certain things within your will. People don't do that, and that's a mistake. I understand why they don't do it, but that's what happens when you don't do it.
So, Lou, you've been a judge twice. What's the one thing you watch lawyers do in your courtroom repeatedly that you wish you could just pull them aside and tell them to knock it off?
It's actually something I have done. Talking over each other, talking over witnesses, talking over me. That was sort of my pet peeve. There's a code of civility, there's a code of conduct that attorneys have to adhere to. I'm pretty sure in every state, but definitely here in Pennsylvania, there's a code of conduct, and you have to act civilly when you're in the courtroom. And you have to act professionally, and I understand that it's an adversarial system, and I don't deny that. But you have to be an adversary with respect and speaking over your opponent, speaking over a witness, um, directing ire towards them is just not acceptable. It wasn't acceptable in my courtroom. I always tried to be a gentleman. I was told a long, long time ago, back when I was a victim advocate, before I um, finished law school and I was about to become a young prosecutor, a judge who's now passed away, Judge Ron Merriweather, an absolute gentleman. And he told me that jobs are going to come and go. The only thing you have in this business is your character and your reputation. If you lose that, you lose everything. He said, always be a gentleman in the courtroom. And I always tried to take that to heart. I've always tried to be a gentleman in the courtroom. Strong advocate. Don't get me wrong. There's a line between being a pushover and being an overzealous advocate. And I try not to go in either one of those sides. I try to make sure that I'm doing what I need to do to get my client's interests at the forefront. But you have to do that in a respectful way, and I think you have to do that in a professional way because we are professionals. And that just doesn't go for the people that are wearing the suits and ties on the other side of the courtroom. That's all the courtroom personnel. That's the stenographer. That's the court staff. Um, that's the people that are emptying the waste paper baskets. You got to treat everybody with respect, in my opinion. And that was one of the things that I demanded when I was on the bench is respect. I gave everybody respect. I never called an attorney out in open court. I would take him into the back and have a private conversation if there was an issue. And I didn't have to do that often. But on the occasion that it came up, that's something that I would do.
So you both watch families tear themselves apart over money and property, in estate fights and divorce court. What's the one thing that almost always makes it worse? One thing that you see that almost always makes those situations worse?
I think what I run into a lot is a lawyer either that goes overboard. They have a case and they think they need to quadruple the evidence and quadruple the vitriol and bombast to get their point across. On the other side also is a lawyer who doesn't have control over his client. And that's important, is that you have to counsel your client that your behavior means a lot, both in the courtroom, in a mediation session, in an arbitration, or whatever. Your behavior speaks volumes. So being unreasonable, having temper tantrums, not getting your own way, and letting everybody know that you're not happy about getting your own way is something that people immediately focus on and they just cross you off. So it's important to control your client and control yourself as well in a courtroom.
So I have another question. So um, you when you have a mediation or when a dispute genuinely needs to go to court, when is mediation a better solution? When you're just when do you pick one versus the other?
Well, I think that usually it's an economic decision because a lot of these types of cases, the client is paying out of his pocket for the representation. And believe me when I say in television, especially, they don't talk about that. They never talk about that. And it's the one thing that clients do not understand is that they think that going to court is free, that the jury trial's free, that, in other words, that it's not going to cost them anything for to have their lawyer in the courtroom representing them. And the same with mediation, especially mediation, it's hopefully a one-time deal. Everybody's invested money. They pay the mediator. They invest money in shortening their whole process, and that's important. So I think it's one thing that people don't really look at is what the cost of these TV uh, lawyer shows are, where they're always in court all the way. Like how much they don't go, how much is this going to cost me? You never hear that, and that's like the number one thing that they got to consider.
Preparing for trial can
Right.
take hours and hours and hours of time. It takes oceans of time to get ready. I used to watch a show, Boston Legal. They would pick up a file at the beginning of the show, and they were done the trial by the end of it within a half hour, an hour. It doesn't work like that. In order to actually successfully litigate, it takes a lot of time, not just to get the information you need, to get expert reports, get depositions done, but then to collect all that, analyze it, come up with your case, come up with your defenses, try to anticipate what your opponents are going to do. That takes a lot of time. It takes a lot of thought. And that's something I think the general public may not really value the way they should, with like other professions. Someone comes in to put a basement in, there's something tangible, it's going to cost X to get that done. You go and you see a doctor, you pay the doctor to help you get better. I think with attorneys, I think especially today with TV and with AI and a lot of other things, I think people don't value legal expertise and legal experience the way that they really should, to be quite honest. And it's expensive, because um, I went to law school just like John did, and we have decades of experience between the two of us, and that's something that has an actual value. And trying to use your client's money wisely, when you sit down with them, you try to say, listen, we could do this way, but this way is going to be a little bit more cost effective. And um, sometimes they should really listen to that, because at the end, then when they get that bill in the mail, they're wondering, why is it costing this much? Well, we discussed this. They don't always necessarily hear what you're saying to them when you're talking about trying to save money.
Yeah, how do you guys market your firm? I'm sure you got 40 or 50 attorneys there. You're probably not that closely involved in it, but maybe on a tertiary, um, touching on that, what do you guys do to help bring new clients into the firm?
Well, I think that one thing that we really do as a firm is we sponsor a lot of events
Hmm.
for, that's probably the number one thing, both for the Bar Association, the myriad of things that they do for that, as well as for charitable, uh, like like fairs. And we'll have this weekend, we're having what they call a steeplechase, which is a kind of a Chester County tradition of horse racing, an open ground. There's a lot of charitable organizations, Lions clubs. It's all over the map. It's all different disciplines, different causes, and that's probably our number one not technique, but that's what we do and what we believe in. I think our firm really strongly believes in charity and developing a better county for the citizens of Pennsylvania.
We have a lot of John's one of them. We have a lot of former presidents of the Bar Association here at MacElree Harvey. So as John said, we're very active in the Bar Association. I just presented at our spring bench bar. I was a co-presenter with a couple of my former colleagues on the bench, and my co-chair of the civil division. So we try to get our information out to people that way. I think we have an excellent reputation in the community, not just in Chester County, but I think in as John said, the Delaware Valley. A lot of it is through word of mouth. We try to do a lot of um, work, as he said, with the charity events, but we also get a lot of clients through other clients, through
Hmm.
existing clients, people that have come to us who I think were very satisfied with the way that they were treated, because we always try to, we don't overbill on cases. We try to be upfront about, this is what it's going to cost, this is where it's going to be, and we give them breakdowns of where that's at, and we try to get good resolution for them. We try to have those hard conversations early on so that they're not surprised at the end. And I think that translates to a lot of satisfied clients that go back out into their community, to their friends and family, their co-workers, and say, hey, listen, I dealt with this attorney. And so I'll get calls even now. I know John gets a lot of calls from people who may have been a client 10, 15 years ago. And it may not be a practice area that John covers, but it'll be somebody in the firm that does do that. And John connects them with other attorneys here. That's the benefit of our firm, because we pretty much have a broad spectrum of practices that we can cover for them.
So you, um, what I gathered out of this is you do a lot, John, you do a lot of family. I mean, you both do some of the similar stuff, but you do a lot of family law type things. And then, Lou, you do, both family law, but you also do some criminal law. Am I accurately characterizing that?
Yeah, that
No.
was, and civil.
Right. I would have to say that I don't do any family law. I don't do divorces. I don't do custody. I don't do separations or anything like that. It's all the families that I deal with are estates, but also I do a lot of contracts, property disputes, corporate disputes, dissolving businesses. I've been appointed by the court to be a partition master, which means dividing a property that are co-owned by two people who can't get along anymore. And the judge will ask me to resolve that dispute as a master. So that's what I do. But a lot of also what I have done in the past is also I've done some personal injury as well. Back in the 90s, I used to do quite a bit of that.
We do have a very vibrant family law, custody, divorce practice group here. In fact, some of the first attorneys from this firm that practiced in front of me when I was sitting on the bench were in the family law group, which was one of the reasons why I was happy to come here, because I knew the caliber of the attorney, because I saw them firsthand. They appeared in front of me. So we, like I said, we have a pretty wide range of practice areas. We have a merger and acquisition unit. We have people that do taxation law, pretty much anything you can think of. We can employment law. So it may not be my area of expertise or John's area of expertise, but I think what happens is when you establish a trust with the person and you help them on a certain kind of a case, when they're looking for somebody to do another type of matter, may not be the type of matter that you handle, but they have the trust in you to know that you're going to point them in the right direction. You're going to put somebody on the case that's going to be able to handle it.
So you have, like, within your firm, you have these different specialties. And so if someone to come to your firm, they wouldn't come for necessarily a specific thing, but they would come for a specific thing, but you guys have specific attorneys who handle various parts of the law.
Right,
so they could
right.
probably find somebody within your firm that's well qualified to.
Right.
That's right.
We have a good litigation department. I do some of the litigation too. So I've done civil litigation, I'm doing criminal litigation, family law litigation, but there are certain aspects that I wouldn't want to take a particular type of case on if it's not my particular area of expertise, because the law is so vast. But anyone who's interested, I would urge them to go to www.macelree.com, www.MacElree.com, and check out our practice groups, because we have a really, really good group of attorneys here.
Okay, that was my next question. If someone was in the greater Philadelphia, Delaware area, or wherever you guys are located, so maybe you want to tell me exactly where you encompass, the best way to get in touch with you. So it'd be to go to MacElree.com, and
Correct.
And what areas do you cover where someone who contacted you who needed help would be able to avail themselves of your services?
Sure. So we do southeastern Pennsylvania, which is the 5-county, Philadelphia, Bucks, Montgomery, Chester, Delaware County. We'll go to Berks County, Lancaster County, the surrounding counties. But we also have offices in Delaware. So we have Delaware attorneys. We have attorneys that go to New Jersey. We have attorneys that are barred in Maryland. So anywhere, as John had alluded to, the Delaware Valley, the 4-state area, we can handle pretty much any matter in those states.
Gentlemen, thanks for coming on the show.
Thank you.
Thank
Zane.
you.
Thank you for having us.
Thank you for having us.